In Scenic International Group Limited versus Adenaike and others, the High Court addressed the consequences of the claimant's failure to file a schedule of costs in advance of a hearing, as required by Practice Direction 44, on the basis that it was felt that it was unlikely that the claimant would succeed in recovering costs, and that it was therefore disproportionate to incur the expense of preparing a schedule of costs. The court found this approach to be mistaken and the failure to be serious, particularly given that the defendants were unrepresented and would have been deprived of the assistance of a CLIPS barrister in scrutinizing the schedule of costs. Taking this failure into account, along with the proportionality and reasonableness of the costs charged, the court assessed the costs on a broad brush basis at £23,235, significantly lower than the £36,000 claimed. Quote, "I have explained that there was no reasonable excuse for the failure in this case, and I regard the failure as the more serious in a case where the claimant knew that the defendants were unrepresented and could have expected, from the experience of the previous hearing in December, that the first defendant would appear in person and therefore have the assistance of a CLIPS barrister on the day of the hearing, but not thereafter. I do not suggest that the claimant's approach was a deliberate tactic to avoid the defendants having such assistance on the matter of costs, but this was nonetheless a foreseeable consequence. I accordingly take this into account, along with my view of the proportionality and reasonableness of the costs charged." For a detailed summary of this decision, visit tmclegal.co.uk.